So now in CBLR 2018, we have a regulation number 11 and 12. Topic is common, that's why I'm talking about 11 and 12. In both of these cases, there is a major change. And what should be done in that situation of major change that we are going to discuss in these regulations. So this I'll explain through this title itself. Now see the title. This is a change in the constitution of any firm or a company. So where does it apply? Regulation number 11. Only if the licensee is a partnership firm or it is a company, only then regulation number 11 applies, otherwise not. Now, if you check the title of regulation number 12, this is also talk about change in constitution. But this change is concern, and concern here it means it is a proprietorship concern. This is a concern means it is a proprietorship concern. So change of constitution of proprietorship concern, that is covered in regulation number 12. And if there is a change in constitution of the firm or a company, that comes under regulation number 11. Right? So did you notice this difference?
Yes, sir.
Right? So title is almost similar. You see first few words, change of constitution, regulation number 11. Regulation number 12 also, this is change in constitution. Difference is here it is concern. So add one word in between here that we are talking about partnership firm. Or sorry, this proprietorship concern. So let me add it here. It is not the part of this actually, but just adding proprietorship. Just to give you more clarity on this. So actually this is not there. So in regulation number 11, this is about partnership firm or a company. Now, what kind of changes involved? One change was covered in regulation number 7. Now I'm taking you back. What kind of changes covered herein?
Change of directors or partner.
Change of director or partner. Whether that person is a license holder or not doesn't make a difference. So as far as regulation number 7 is concerned, this is talk about the intimation being given about change in director or partner. The time limit given is 1 month. Within 1 month, intimation must be given, nothing else. It is only the question of giving the intimation. It is said it shall be communicated. Okay, so matter ends only by giving the information. But what happens if the person, the partner or the director happens to be a F card holder whose license is being used? Then this is not the question. Then it will go under regulation number 11. Regulation number 11. Okay, this says in the case of any firm or a company granted a license under these regulations. Now see, any change in constitution which makes the holding of such a license invalid in view of the conditions specified in clause B of sub-regulation number 2 of regulation number 7. So what is in regulation 7(2)(b)? One of the partner or director or employee must be a F card holder. Okay, so if that condition fails, then what happens? When the license becomes invalid. So if the person has left that place, so leaving maybe for multiple reasons. Maybe person has retired, maybe person has resigned, maybe person has died, for number of reasons, but there is a change. So the person is no more there. that license given to the firm or the company, that becomes invalid automatically. Your license is associated with the individual, even if it is issued in the name of company or firm, but ultimately, as long as the individual is there who has completed the education as per the requirement of regulation number 6 and 7, only then that license is workable, otherwise not. So when it becomes invalid, what happens? This is notwithstanding in continued engagement of employment of a person who has passed the examination regulation number 6. So there may be some other person also in the firm who is qualified. They say notwithstanding the continued engagement or employment of the person who has passed the examination. So this is a case where some other person is also employed. But the firm cannot use the license of two persons at the same time. Company cannot use license of two persons at the same time. So actually in this, what we are talking about, if the person whose license was being used by the firm or the company has left, whatever be the reason, then what happens? Then such changes shall be reported to the firm or company, as the case may be, to the PCC or CC forthwith. Now, what is the time limit given here is for the intimation of the change? Within how many days information of this change should be given?
Forthwith.
This is forthwith. No time limit is there. Inform that change immediately. And then apply for another license. And any such firm or company undergoing such change shall make a fresh application to the said PCC or CC within a period of 60 days from the date of change for the grant of license under regulation number 7. So this question of 60 days arises only if there is another license holder with the firm or company. What happens if there is no other qualified person? What will happen if there is no other qualified person? So if there is a qualified person, first of all, give an intimation immediately, then make an application for another license within a period of 60 days, and then the license will be issued. And in the meantime, permission will be granted to carry on the business. The firm or company making application referred to sub-regulation number 1 after then provided that licensing firm or company moves an application for the change, then such firm or company may be allowed to carry on the business as a custom broker with the approval of PCC or CC. So application made, issue of the license may take some time, but in the meantime, PCC or CC will allow the firm or company to carry on the business. Now there is another change. Now see what is written here in. This is whatever written in sub-regulation number 1. That is one part. What happens if that requirement is not fulfilled? So what is the requirement of under sub-regulation number 1? There is another F card holder in the firm or company. If that is not there, then what will happen? Then sub-regulation number 3 becomes applicable. This says, in the case of a firm or company where the license is ceased to be enforced because of death or retirement of any partner or director or authorized employee, who has passed the examination referred in regulation number 6, the firm or company may apply for the replacement of the name of the demised person by the name of another partner, director, or authorized employee who has passed the examination. So this is again application within 60 days. But if provided that if there is no such person in the firm or company, if there
Sir,
is,
what is the meaning of notwithstanding anything?
notwithstanding means this will carry overriding effect. Sub-regulation number 3 will have overriding effect over sub-regulation number 1 and 2. Do you understand what is the overriding effect?
Yes, sir. This will get priority first.
Exactly.
Regulation 3.
Okay, so why it is being said is that it is because of this. If there is no such person in the company, then what to do? It means these two provisions are independent of each other. If there is if you already have some other qualified person, make an application for another license within a period of 60 days. And before that, as soon as there is a change, inform the change. But what happens if there is no other qualified person? Then this proviso becomes applicable. They say, then such firm or company or the company, as the case may be, may authorize any other partner, director, authorized employee, but who is a G card holder. who must be a G card holder. So by chance, if somebody has committed an error that he is already having the custom broker firm, but he doesn't have anybody who's a G card holder, he's committing the greatest mistake. Because if there is no other G card holder, then only option available is within 60 days from the date of retirement or demise of the license holder, there must be another F card holder, and F card holder are not available in the market freely.
To watch full video, join the regular online batch Call Tayal Institute.